Hi, I'm Sam Fischer. I work on the social media and PR marketing for Noli IP, and this is Mariana, our founder. Hi, Mariana.
Hi, Sam.
So this week is Tea with Noli IP, and we're talking about litigations.
Well, I'm very excited to have this conversation with you. Let me share the presentation that you prepared for all of us. All right. Here we go. Tea with Noli IP, litigation.
Okay, so my first question is patents, copyrights, trademarks, and trade secrets. What do I need and when?
Well, we had prior episodes of the Tea with Noli IP where we explained what is protected under patents, inventions, what is protected under copyright, original works of authorships, what are the trademarks protecting, and that is the source identifier of goods and services, and that could be a word, a slogan, a design. We also talked about the trade secrets, and that protects the practice and the process that a company generally uses and is not known outside the company to do business.
Okay. My next question is, what is the most common violation of intellectual property?
When we talk about infringement, is when somebody that is not the rightful owner or that doesn't have any rights to the intellectual property without authorization of the owner uses. Let's just say it could be infringement of a patent, infringement of a trademark, or infringement of a copyright. So it could apply to any of these categories of intellectual property rights, but it would be infringement.
Okay, that makes sense. My next question is, I believe my intellectual property has been stolen. What is my recourse?
And what we do here a lot is not only help our clients protect their intellectual property rights and educate them, but also enforce their intellectual property rights. Because what would be, you protect your trademark, you protect your copyright, and then somebody else is using it. It really can affect the owner, the rightful owner of the copyright. So the first step I would say is to send a cease and desist and request that the infringer cease the unauthorized use. You could also alternatively, if you don't really want to keep the exclusive right, you could grant a license. So, and the last recourse always is to sue for damages in the court, right? So there are many options.
All right. So, mediation versus arbitration versus litigation. What is the difference?
Well, when we talk about the litigation, is the legal term for a lawsuit, and I'm sure that you've seen online Apple, involved in many different lawsuits for patents matters. So litigation refers to when you are in the court, right? When there are two parties that are arguing different viewpoints. There is one that alleges infringement, the other one is defending itself, maybe even countersuing. So that is litigation. It refers to the lawsuit and the process in court. Another alternative is mediation. And oftentimes when you do file for a lawsuit, the court will require the parties to be part of a mediation process. The idea is that at times, maybe the parties don't even know it, but there is a possibility of solving the issues because what they really want may not be something that the other party does not want. So they could come to a solution in a mediation. The mediation, the decision that is made during the mediation process is not the judge ordering the parties something. The parties come together in an agreement. So it is a non-binding process, right? And like it says here, it's conducted by a mediator. It is not a judge, and mainly facilitates the discussion and the possibility of a settlement. The arbitration is a binding process, and that's why I would say that it's a little bit closer to the litigation in where there is a decision that is made and the parties are bound to the terms of that decision. So it is binding.
Okay. My
I
next
confuse you. Yeah, these are technical terms, but the differences are pretty clear.
Mhm. So my next question, do I need an IP lawyer and how do I choose an IP lawyer?
100%, you always need an IP lawyer. Of course, sometimes you could represent yourself, but I highly recommend that you find an IP professional that helps you navigate. This is not as simple as it may seem. So obviously having the professional legal representation can help your case. So I highly recommend it. And when you are looking for one, I guess one of the things that I suggest you look is how many years of experience such an attorney has, how long has he or she, sorry, because in my case, like it would be, how long have I been in practice, if I have any recognition in my field, the reputation. Track record is very important, right? And I even look at this when I'm dealing with opposing counsel to see, are they very aggressive? What is, what is their track record? Yeah.
Those are some good things to look for. My next question is, how costly is it to litigate? And do I need a litigation budget?
It's very, very costly. People don't realize how costly it is. I do think that this is the last recourse that an applicant has, or that an owner of IP rights has to enforce their rights. It can go in the hundreds of thousands in the United States. So I do recommend, sometimes business insurance policies cover the cost for business related litigation. So you can check with your insurance and see if that is covered under your policy. If not, there are also companies that do financing for litigation matters, and that could be something that you look into. If you have a very strong case, typically they would get a percentage. For example, our law firm doesn't take matters on contingency nor partial contingencies just because of the nature of intellectual property law, but there may be law firms out there that do take matters on a contingency basis. By the way, some contingencies basis, that means that the attorney or the firm will get paid when they win the case at the end of the matter.
Okay.
I could just tell, that maybe you were like wondering. Yeah.
Yeah. So how long does it take to reach a judgment?
Well, and I guess it really depends, right? From beginning to end, because most of the cases settle. So I guess they say something like 90% of the cases settle before the end of the trial. They don't even go to trial. So it can be the system, the federal court system where most of these matters take place. It's pretty efficient, but it could take a year or 2 years, and again, most of the matters settle before they reach the trial.
Okay. So what is the difference between state and federal court?
And I have to say, relating to the prior question, that it really depends. Sometimes the matters do take longer, okay? So it's not like all the matters are in a few years, you have a decision. It really depends. So the difference between the state and the federal court system, I guess, the federal court is more of an exclusive forum that can only hear certain matters when it comes to IP, because trademark law is federal law, and patents as well as copyright. These issues typically can be brought to the federal court, and the jurisdiction of the federal courts is very narrow. So there has to be certain requirements. Like here it says it has to involve federal laws, or it has to involve citizens of different states. So not any case, not every case you can bring to the federal court.
Okay. My next question is, what is a litigation hold?
And this term, the litigation hold, I've been practicing for 14, almost 15 years. And I remember when I first started practicing at one of the law firms that I work for, my boss told me, so you don't know what's the litigation hold. It was funny because I knew this as a document retention notice. This is a document that you send your client, let them know that there is a litigation that is being filed or that that has been filed already, and you want them not to get rid of any documents because all these documents are going to be essential to prove your case. You know how sometimes when you're running a business, you want to get rid of the paperwork and unnecessary documents. Well, but the way that we reconstruct what has happened is with the documents. So we want to make sure that the clients don't get rid of documents that could help the case.
Yeah, that definitely makes sense. So my next question is, what are the financing options for litigation?
And I got ahead of myself when we were talking about the litigation budget. I kind of made a reference to this because you asked me, well, what would be the budget? Really is very difficult to assess. I mean, you shouldn't file a lawsuit thinking that the other side is going to settle right away because you don't know what can happen. There is a lot of uncertainty if you have a very strong case even. So I suggest that you do look into there are some companies out there that do financing for litigation, and that could be an option. You could also look into maybe if your insurance company would finance the litigation or would cover your litigation. And there are some firms as well that may take the case on a contingency. So there are things that you can do before you file your lawsuit in court.
All right. Well, those are all my questions, and thanks for giving me the info.
You know what? Thank you so much.
Bye, Mariana.
Bye bye.